We have received questions about our measures for eliminating racial discrimination. The Constitution of Japan stipulates in paragraph 1 of Article 14 that all of the people are equal under the law. Japan acceded to the International Convention on the Elimination of All Forms of Racial Discrimination in 1995. The International Covenant on Economic, Social, and Cultural Rights and the International Covenant on Civil and Political Rights, to which Japan became party in 1979, also prohibit discrimination on the grounds of race and ethnicity. Based on the principle of the Constitution and the Covenants, Japan has been striving to realize a society without any form of racial or ethnic discrimination. In order to prevent human rights violation by racial or ethnic discrimination, our government pursued the strict implementation of relevant domestic laws and promotes activities for raising public awareness. Let me now respond to the question of discrimination of women. Based on the basic law for a gender-equal society, our cabinet adopted the second basic plan for gender equality in December 2005. The plan defines the necessary measures to promote policies to form a gender-equal society in a comprehensive and well-planned manner. Under this plan, the government of Japan implements concrete measures to eliminate discrimination of women. Concerning the role of NGOs, our government asked opinions from all levels of civil society, including NGOs, for preparing and drafting the second basic plan for gender equality. We also wish to hear opinions from NGOs when we revise the basic plan in the future. There was also a question regarding Japan's marriageable age. In February 1996, the Legislative Council of the Minister of Justice submitted an outline of a bill to revise part of the Civil Code, suggesting, among other things, that a marriageable age should be 18 years of age for both men and women equally. This issue constitutes an important subject that involves the marriage system and the concept of a family. Since there are various opinions across all levels of civil society, close attention is currently being paid to the trends in public opinion. We have received a question on the treatment of detainees. As was explained in our national report, Japan has been making active efforts to improve its criminal justice proceedings through the enactment of a law in 2005 and another law in 2006 to completely revise the legislations governing the treatment of sentenced inmates and the treatment of pre-sentenced inmates respectively. This demonstrates the effort of the Japanese government to improve the treatment of detained persons. Let me respond to the question about the police detention system. In Japan, except in the case of being caught in the act of a crime, a suspect cannot be arrested without warrants. In addition to this, the necessity of detention will be strictly examined by the police, a prosecutor, and a judge in due order, and then a judge will decide its necessity and placement of the detention for a maximum of 10 days. A prosecutor and a judge will respectively review the necessity of extension of the detention, and a judge order is also necessary for the extension. Detention is strictly controlled by the judicial authority. Moreover, the extension cannot exceed 20 days in total. Thus, detention is limited only to short term. Under such condition, the substitute decision system that keeps suspects in police detention facilities as an alternative to detaining them in penal facilities is indispensable to carry out prompt and effective investigation. I would like to stress one more thing. At the police detention facilities, the investigation division and the detention division are totally separate organizations. Investigative officers are not allowed to control the treatment of detainees. Detention operations are conducted by the detention division of the facility, which is not involved in investigations at all. The police detention facilities treated and treats the detainees with due consideration to the human rights. Regardless of the type of crime committed, detainees can have consultations with their lawyers at any time, even on holidays or evenings, except late at night, at their right to defense. There is no official watch person during the meeting and no time limitation. Furthermore, under the Penal and Detention Facilities Act, the principles of the separation between investigation and detention is made legally clear. And a new system has been introduced to make up a third-party committee to inspect detention facilities and to state their opinions on the management of the facilities. In addition to that, the complaints mechanism has been developed in order to ensure appropriate treatment of detainees. With regard to the treatment in the inmates in the penal institutions, Japan does its utmost to conduct appropriate treatment in full respect of human rights in accordance with new legislation which defines rights and obligations of inmates and also regulates the requirements and procedures to restrict inmates' behavior and lifestyle. Compared to the old law, the new law provides additional care for the loan and supply of clothing and food. The range and requirements of using self-supplied articles are clarified. The living standard of inmates has been raised through guaranteeing adequate hygiene and medical care. The complaint mechanism has been improved. Thus, the new legislation shows increased consideration for the human rights. As for the issue of overcrowded prisons, Japan is trying to settle this issue by constructing new penal institutions to expand the total capacity.